Good morning. We are now on the record in the matter of the appeal of Ricky T. Burningham, OTA case number 18-01-0865. This hearing is taking place in Sacramento, California on April 30th, 2019, and the time is approximately 10 a.m. The panel of administrative law judges includes Tommy Malm and Jeffrey Angija, as well as me, Alberto Rosas, and although I may be the lead AOJ for purposes of conducting this hearing, this panel, the three of us, we are all equal decision makers. We're going to get started with appearances. Please state your names for the record, starting with the taxpayer.
Rick Burningham. David Kowalczyk for respondent.
Natasha Page for respondent.
I'd like to remind both parties that we are on the record. This matter is being recorded by a stenographer, so please remember to speak slowly, speak clearly, and please try not to speak over one another. We held a pre-hearing conference earlier this month on April 11th, 2019, which resulted in 5 orders. The first one is that Mr. Burningham's exhibits 1 through 8 were admitted into evidence. Second, FTB's exhibits Alpha, Bravo, Charlie, and Echo, that's A, B, C, and E, were admitted into evidence. Number 3, only one witness, Mr. Burningham, shall testify at today's proceeding. Number 4, today's hearing is expected to take no more than 50 minutes, and the parties are expected to comply with the specific hearing time limits that we discussed. 5th, Mr. Burningham was granted permission to record the oral hearing using his own audio recorder. Is this an accurate summary of the pre-hearing conference notice, Mr. Burningham?
I believe so.
Yes, Judge. In regards to your recording device, Mr. Burningham, I would just like to point out and remind you that the stenographer's transcript is the official record of today's proceeding. Before we begin with the presentations, does either side have any questions?
Yes.
In that case,
Just one.
yes, Mr. Burningham.
During the oral phone conference, we discussed the fact that I had a criminal complaint that I would be able to read from them. I brought copies for everybody in case they wanted to review it as I read it.
We don't need copies. We have the complete administrative file of everything that was submitted in this case. Thank you for offering that, Mr. Burningham.
Judge, can I ask that he close his briefcase so I can see him?
Oh.
Thank you, Ms. Perry. Thank you, Mr. Burningham. Mr. Burningham, whenever you're ready, you can please rise and I will administer the oath. Raise your right hand. Do you swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, Mr. Burningham. Please be seated. Mr. Burningham, you will have up to 20 minutes. You may begin your presentation whenever you are ready.
We start with the fact that the FTB's presumption that enforcement is legitimate without examining the law. I think I presented that with the briefs that I had, the briefs that were presented through the petitioning for a hearing process. Is that correct? And you have those. You have my briefs, my response briefs, and everything. And the FTB did not respond to the last brief that I had. Is that correct? So it was left unresponded. I would like to start with facts. I had the brief from October 2nd, and that's a balance reply brief to the respondent's brief of September 5th, this is dated. Appellant did present a brief. It was a criminal complaint, Exhibit A, in a timely fashion, replete with the statutory and regulatory references, provided facts that there was no legal requirement to report any gross income in order to file a 2013 California return. as demanded by the first notice, which was the demand for a return. Exhibit A. I go to page 2 of that exhibit. The top left corner says, steps to determine filing requirement. Is your gross income? Note it says gross income. All income you receive from all services in the form of money, goods, property, services, and are exempt or that are not exempt from tax more than the amount shown on the table that is presented on page 2 of this. I presented that in a brief as a response to that demand for a return. You have that record. Okay. Respondent's presumption, the FTB has a presumption that all receipts are gross income. Right out of the starting gate, I want to read. From the Supreme Court. Southern Pacific versus Lowe. Yes. 247 U.S. 330, 1928. We must reject the broad contention submitted on behalf of the government that all receipts, everything that comes in, are income. Okay. I presented statutory explanation of why that is. The foundation of the FTB and the presumption that we owe tax or have gross income is Section 61, adopted Revenue and Taxation Code in the California Revenue and Taxation Code. Okay, that's a foregone conclusion. Section 61. I think we know what Section 61 is. Excuse me. General definition. It says gross income defined, Section 61, general definition A. Except as otherwise provided in the subtitle, gross income means all income, whatever source derived, but not limited to the following items. It gives items 1 through 14. The first phrase, except as otherwise provided in the subtitle. It's very important to note. That's a subordinating clause. It's like saying, notwithstanding Section 61, if there's another subtitle or if there's another statutory or any other explanation of gross income or what it means and what it is, you have to take that into consideration. I thoroughly and exhaustively and articulately explained Section 83. You can't escape Section 83. If you go to Section 61B, which it says, cross-references, it says, for items specifically included in gross income, see Section 71 and the following. You look at the list, it's like 71 through like 90-something. Section 83 is in there. It's for those things that are specifically included in gross income. Section 83, this is the operative language, please.
This is what?
The operative language of this section. I'm not going to read all of it. Inoperative language. Property transferred in connection with the performance of services. In connection with the performance of services, property is transferred in excess of the fair market value of such property over the amount, if any, paid for such property shall be included in gross income of the person who performs such services. Section 83A explains how property received in exchange for services is taxed. See Leper system versus CIR. 956, Fed 2nd, page 496, 498. 1992. The Court of Appeals on 3 different circuits has ruled that Section 83 applies to all compensation for services, and it explains how to tax it. But one would be hard-pressed to explain how 83 allows the fair market value to be included in gross income. Section 83 addresses fair market value, excess, and gross income. But only the excess is associated with gross income. How can an individual include the fair market value and gross income without violating Section 83? It cannot be done. Regulations refer to all the other sections of statute that allow deductions and talk about the basis, associated basis and everything, the basis, or what you would call the, let's see, let me do this, adjusted basis and everything that you deduct. Excuse me, I'm very nervous. All the implementing regulations do refer to property exchanged with connection with performance and services that applies. Section 83 applies. It refers to other sections of the code. It's in my criminal complaint. Sections 1001, 1011, 1012 all refer to basis and adjusted basis, what can be deducted, what can be included in gross income. These are all included in the criminal complaint as being violated by the Franchise Tax Board. Okay. I have an immense amount of information here. Please bear with me. I'd like to talk about property rights. My labor is property, that all property is cost. And I'd like to read from a little bit from Black's dictionary, law dictionary. I have one, my personal one, fourth edition. But anyway, property, that which is peculiar or proper to any person, that which belongs exclusively to one, in strict legal sense, an aggregate of rights which are guaranteed and protected by the government. The term is said to extend to every species of valuable right of interest, more specifically ownership, an unrestricted and exclusive right to a thing, the right to dispose of a thing in every legal way, to dispose of it, to use it, and to exclude everyone else from interfering with it. The dominion or indefinite right of use or disposition which one may lawfully exercise over particular things or subjects. The exclusive right of possessing, enjoying, and disposing of a thing, the highest right of a man that can have to anything, being used to refer to the right which one has to lands or tenements, goods, or chattels, which no one depends on another man's courtesy. Property within constitutional protection denotes group of rights inherent in citizens' relation to physical things as rights to possess, use, and possess of. It is goodwill. Goodwill is property. Intangible property, property which cannot be touched because it has no physical existence, such as claims, interests, and rights. Personal property, a right or interest in things personal, or right or interest less than a freehold in realty, or any right or interest which one has in things movable, personal property, includes money, goods, chattels, things in action. It's California Evidence Code. We'll move into Supreme Court rulings regarding property. I already read one, which was Southern Pacific versus Lowe. In Butchers Union versus Crescent City, 1884, it's 111 U.S. 746. At pages 756 through 757. As in our intercourse with our fellow men, certain principles of morality are assumed to exist, without which society would be impossible. So certain inherent rights lie at the foundation of all action, and upon a recognition of them alone can free institutions be maintained. These inherent rights have never been more happily expressed than in the Declaration of Independence, our organic law. That new evangel of liberty to the people. We hold these truths to be self-evident, but it is plain that their truth is recognized upon their mere statement that all men are endowed, not by edicts of emperors or decrees of Parliament or acts of Congress, but by their Creator with certain inalienable rights. That is, rights which cannot be bartered away, or given away, or taken away except in punishment of crime. And among these are life, liberty, and pursuit of happiness. And to secure these, not grant them, but secure them, governments are instituted among men, deriving their just powers from the consent of the governed. In Butchers Union, among these, this is part of that, Butchers Union, among these inalienable rights is proclaimed in the document is the right of men to pursue their happiness, by which is meant the right to pursue any lawful business or vocation in any manner not inconsistent with the equal rights of others, which may increase their prosperity or develop their faculties so as to give their highest enjoyment. The common business and callings of life and ordinary trades and pursuits which are innocuous in themselves have been followed in all communities from time immemorial. They must therefore be free in this country, and all alike upon some same conditions. The right to pursue them without let or hindrance except that which is applied to persons of the same age, sex, condition is a distinguished privilege of citizens of the United States and an essential element of that freedom which they claim as their birthright. Within this case that I quote now is an excerpt from Adam Smith's quote. It has been well said that property which every man has is his own labor, as it is the original foundation of all other property. So it is the most sacred and inviolable. The patrimony of the poor man lies in the strength and dexterity of his own hands, and to hinder this employment, his strength and dexterity in what manner he thinks proper without injury to his neighbor is a plain violation of the most sacred property.
Mr. Burningham, just as a courtesy, I want to let you know you have a little more than 5 minutes.
Thank you. Unquote. In Coppedge versus Kansas, another Supreme Court ruling, 1915, included in the right of personal liberty and the right of private property, partaking of the nature of each, is the right to make contracts for the acquisition of property. Chief among such contracts is that of personal employment, by which labor and other services are exchanged for money or other forms of property. Every man has a natural right to the fruits of his own labor. This is antelope. I'm moving on. Every man has a right, let me explain this, the antelope, 23 U.S. 66, page 120. Every man has a natural right to eat the fruits of his own labor. And as generally admitted that no other person can rightfully deprive him of those fruits and appropriate them against his will. In the Evans versus Gore, 253 U.S. 245, 1920, the 16th Amendment does not justify the taxation of persons or things previously immune. It was intended only to remove the occasion of any apportionment of income taxes among the states which were the Supreme Court taken off. The Supreme Court in Bushaver said it was an excise tax, which has to be follow the rule of apportionment or it's not apportionment, it's uniformity, excuse me. Sorry for that lapse. The Constitutional Amendment 16 authorizes Congress to collect taxes on
Can you slow
incomes.
down, please?
Huh?
Slow down.
Okay. Constitutional Amendment 16 authorizes Congress to collect taxes on incomes from whatever source derived without apportionment among the states. Does not extend the taxing power to new or accepted subjects, but merely removes all occasion. I'd like to point out the fact that when the 16th Amendment was supposedly ratified, that wages, salaries, labor was not taxed. Okay? It was only until 1942 when the victory tax was taken and we were in an exigency for Section 61. In the United States, statutes at large, we have a record of gross income being defined in Section 22, the predecessor of 61 today. General definition, Section 62, gross income includes gains, profits, and income underlying derived from salaries, wages, and compensation for personal service. It has to be a derivative. Courts have already explained that very, very clearly. The Supreme Court's done it. I don't know why there's so much contention about that with federal district courts. It's certainly a due process problem. Okay. The history of the Section 61, because the Franchise Tax Board uses it as its foundation. Section 22 of the 1939 Code. It originated in 1918 with the Underwood-Simmons Act. It was a tariff act. If you look at all the income tax acts, you look at the regulations, you look at the history of income tax, there's a nexus to foreign, non-resident aliens, and foreign corporations.
Mr. Burningham, we have approximately 2 minutes left. You can start by being out. Thank you, sir.
Okay, thank you. So, nothing's changed. Most of these tax laws, from tax acts from year to year, were in lieu of the tax acts before. Congress declared that Section 61 is no different than Section 6. It has the same meaning as Section 22 of the 1939 Code. That very specifically talks about the fact that it has to be derived from salaries, wages, and income. It's not taxed on labor. It never has been. I don't see where the law says anything otherwise. Presumptions of everything that comes in as gross income is not verified or based upon law and Supreme Court justice or Supreme Court rulings. I think under the circumstances, I have plenty of regulations saying that Section 83, which is the statute that governs the taxation of those who provide services for the exchange of property. I can't define a paycheck any better than that. I think I could summarize everything, the fact that Section 83 stands. It's been there since 1969, before I started filing, and before I figured out that I didn't owe this tax and have no requirement. I don't believe for 1 minute that I have a lawful duty to pay this income tax, that they call it income tax. I have plenty of articulated briefs that explain that in detail, and it's never been challenged. The record is barren from the Franchise Tax Board of any language of Section 83 and the stipulated related sections of the Code 1001, 1011, 1012. That is in violation of their sections of Revenue and Taxation Code 1700 or 1781, 17,201, and 18,301. They're in violation, and on the record, I need to make it known, as my criminal complaint says, they're violating Title 18, Section 241, Conspiracy Against My Rights, Section 1341, Frauds and Swindles, Section 1343, Mail Fraud, Section 1950 1, extortion, 1962, is it? I believe I can verify that. 1962.
Mr. Burningham, we'll pass the time, but we will return back to you after FTB does her presentation, so you will have the last word, sir.
Thank you.
Thank you. Mr. Kowalczyk, do you have any questions for Mr. Burningham?
No, Judge.
Judge Nung, do you have any questions for Mr. Burningham?
No.
Judge Ajija, do you have any questions? No. And Mr. Burningham, I also do not have any questions for you at this time. We will now turn it over to the Franchise Tax Board to make their presentation. FTB, you will have up to 15 minutes. You may begin whenever you're ready.
Good morning. The issues before us today is whether appellant has met his burden of proof to show error in respondent's proposed assessment and reasonable cause to evade the delinquent filing penalty for tax year 2013. Appellant has failed to file a 2013 tax return and has made the same frivolous arguments that many taxpayers have made before him. Appellant's arguments relating to Section 83 of the Internal Revenue Code is a variation of the theme that wages are not taxable. The Office of Tax Appeals, the State Board of Equalization, and the federal courts have all emphatically, uniformly, and consistently held for many years that wages are taxable. Appellant's federal wage and income transcript confirms appellant received $53,466 in wages from Redwood Electric Group, Inc., and $6,836 in wages from Sprague Electric. Appellant has not denied he received these wages or was employed by either of these companies. In regards to the delinquent filing penalty, appellant has not provided any reasonable cause explanation for why he has not filed a tax return besides the frivolous arguments. Accordingly, appellant has not met his burden of proof to establish error in respondent's proposed assessment or reasonable cause to evade the delinquent filing penalty. Therefore, respondent's action must be sustained. Thank you.
Thank you, Mr. Kowalczyk. Judge Nung, do you have any questions for FTB?
No, I do not.
Judge Ajija?
No, thank you.
And I also do not have any questions for FTB. Thank you. Mr. Burningham, we will now return to you. You will have the last word. You will have up to an additional 5 minutes. You may begin whenever you're ready, sir.
All I presented in this court, or in this hearing, Supreme Court rulings, statutory pleadings, and regulations. I presented to the Franchise Tax Board a brief and response with a 66-page copy of the current, which they refer to by within their correspondence. They gave me the sites and everything to go to. I copied that out and I sent it back to them. If petitioning government for redress of grievances is a frivolous argument, go on this record, public record right now. Okay? Everything I presented is not on that list, or that list of, that's the official list. They've had Section 83 for 25 years, and it's not in that list. Now, if petitioning government for redress of grievances is a crime, and I deserve the penalties that I've been receiving from the Franchise Tax Board, then we need to address that now. We need to address that. I received 3 frivolous submission penalties from the Franchise Tax Board. They base, by adoption, they base these things on Section 6702, Subtitle F. All right? Apparently they haven't read Subtitle F. Congress shall make no law abridging the right of the people to petition the government for redress of grievances. First Amendment. The state of California is inseparable from part of the American Union, and the Constitution of the United States is the supreme law of the land. All men are free and independent and have certain inalienable rights, among them which are those to enjoy and defending life, liberty, and acquiring, possessing, and protecting property. Appellant jealously guards his fundamental rights. There's being no exception to revenue collection purposes and waives none. It is his wish that the state of California, which is a municipal for-profit corporation, cease interfering with his right to redress his grievances in the forum and cease harassing his family. The first appearance of Section 6702 was found in 1986, subtitle F. It imposed $500 frivolous penalty. In 2006, it was increased to $5,000 and changed the subject to any person filing a frivolous return or statement. The amendment has mandated from the Secretary of the Treasury shall prescribe and periodically revise a list of positions that the Secretary has identified as being frivolous. I presented that to the Franchise Tax Board. They never returned one iota. As far as I know, that's their responsibility to answer my questions. If they can put their finger on the taxpayer, they need to put their finger on the tax law. Excuse me for being angry. Any penalty arbitrarily assessed against a natural individual man for the purpose of interfering with free exercise of the constitutionally protected rights, such as a free speech or redress, must be reported as a criminal act of oppression and extortion. Cal Penal Code 518 through 527. Congress expressly withheld the application of the frivolous filing penalty. If you read section 7851A6A, you'll find that it's never been enacted. There is not an enactment date to that subtitle, or to subtitle F. Okay? And they use it as if they have a tantrum every time, and they come after you and say, withdraw your protest, which they call a protest. I call it a petition for redress of grievance. And I've always put that in my writing. It's always been in writing. They say, withdraw that or be subject to this fine. If I withdrew it, I would submit to the fact that they say that you owe this. Okay? Whether I owe it or not, by law or by statute or anything. Policy, practices, and procedures are not law. This is fake law. Let me put that on the record. If a law has no purpose, then it shield to the assertion of constitutional rights by penalizing those who exercise them, that it is patently unconstitutional. The term person as used in this chapter includes the officer or employee of a corporation or a member of an employee or a partnership who is such officer, employee, or member as under a penalty to perform the act in respect to which the violation occurs. Appellant, not being a creation of the state, denies that he possesses the requisite corporate persona to be charged with any duty to perform any act for which the amended subject designation of person could possibly apply. The type of tax that the class of persons liable for the penalty are ruled inapplicable to the personal income tax by the Supreme Court in 1978. Any state court, tax court, USDC decision, or Bureau of Publication to the contrary notwithstanding.
Mr. Burningham, we're past the 5 minutes, but if you just wrap it up in the next 30 or 60 seconds, that would be great. Thank you.
When Congress added the phrase modify in person, it was not seeking further to describe the class of persons defined in 6671B, upon whom fell the responsibility for collecting taxes. I think I've explained it good enough that that is a violation of law. It's not been enacted. They cannot prove with implementing regulations nor an enactment date that that's even law. It's under the color of law, and I state it here on the record.
Thank you, Mr. Burningham. That concludes the hearing in the appeal of Ricky T. Burningham, OTA, case number 18010865. The record in this matter is now closed, and this matter is submitted as of today, April 30th, 2019. This panel will issue a written decision to the parties no later than 100 days from today. Thank you all very much.
Thank you, Judge.
Yes. Very ready. Good afternoon. We are on the record in the matter of the appeal of Earle and Evelyn Malm, OTA case number 1801-1703. This hearing is being convened in Sacramento, California on April 30th, 2019, and the time is approximately 1:20 p.m. The panel of administrative law judges includes Sarah Hosey,
Good afternoon.
Jeffrey Margolis,
Good afternoon.
and me, Alberto Rosas. And as I mentioned during our recent in-person pre-hearing conference, there was a recent change to the panel. Mr. Margolis is replacing Judge Grant Thompson, who was listed in the notice of tax appeal panel that was issued on February 15th this year. Now, although I'm the lead AOJ for purposes of conducting this hearing, please note that this panel, the three of us, we are all equal decision makers. So we're going to start with appearances. Please state your names for the record, and we'll begin with taxpayer side.
My name is Earle Malm, and I'm the taxpayer in the case. Timothy Mulgrew, representing the taxpayer.
David Hutter, franchise tax board.
David Gagnon, counsel for tax board, franchise tax board.
Michael Cornaz, franchise tax board.
And as you gentlemen are aware, this hearing is being recorded. We have a stenographer, so please just be mindful to speak slowly, speak clearly, and to try not to speak over one another. We had a telephonic pre-hearing conference April 11th, 2019, which resulted in 4 orders. Number one was that we admitted respondents' exhibits C, Charlie, through exhibit VV, Victor Victor, into evidence. Number two, we agreed that only one witness would testify today. That's Mr. Malm. Number three, we discussed that this hearing will take approximately 2.5 hours, and the parties are expected to comply with the specific hearing time limits that we discussed. And number four, we agreed that OTA shall not consider the pre-hearing conference statements as additional briefs. Is this an accurate summary of the pre-hearing conference orders? Mr. Mulgrew?
Yes.
Mr. Hunter?
Yes, Judge Rosas.
And this afternoon, before this oral hearing, we met in person for a in-person pre-hearing conference, and we agreed that we would admit 4 additional exhibits. We labeled the notice of action for tax year 2010 as Exhibit 1. The notice of action for 2011 was labeled as Exhibit 2 for identification. The notice of action for tax year 2012 was pre-marked for identification as Exhibit 3. And as Exhibit 4, we pre-marked an excerpt from Appellant's reply brief, Part 2. 3 pages which included a summary or narrative of some of the hours that were reportedly worked by Mr. Malm during the tax year's issue. As was discussed, Exhibit 4 is not coming in to prove those exact hours. It's not coming in for the truth of the matter stated in that exhibit. We are just bringing it in for the purposes of avoiding an undue consumption of time to prevent having to have Mr. Malm read line by line those 3 pages into the record. Is that correct, Mr. Hunter? Is that my understanding of our concession regarding Exhibit 4?
That's correct, Judge Rosas.
So I hereby admit Appellant's Exhibits 1, 2, 3, and 4 into evidence. Gentlemen, before we proceed with opening statements, is there anything else either you would like to discuss or do you have any other questions for me this time? Hearing none, we will move into opening statements. As we discussed, each of you has up to 5 minutes to make a brief opening statement. Mr. Mulgrew, you may begin whenever you are ready.
Thank you. We've been on a long journey to get here through a large number of issues, a large number of debated issues. We are thankful to be here in front of an impartial panel to hopefully see justice brought about on this case. The issues have been seemingly all over the place from our perspective. It appears we finally have nailed it down to the crux of the case. Seems to be that the appellant's W-2 income is too high to allow material participation. This comes from an audit technique guide produced by the Internal Revenue Service that says one of the things to look for that may indicate somebody who's not materially participating is high W-2 earnings from other sources. The next issue appears to be that the appellant was paying management fees to another, and that also from the audit technique guide seems to go against the idea of material participation. And so ultimately this case boils down to whether or not this is a case of IRC 469 material participation. The state's application of the rules seems to make sense on their face, and I don't disagree with how the state is applying. I disagree with how the state is applying to this particular case. The facts and circumstances you'll see through testimony will demonstrate that that rule doesn't generally apply based on the congressional intent of the application of it. Testimony will show the facts of the case are very different than what they're being portrayed. We intend to demonstrate how the appellant's W-2 income could very reasonably be what it was and have substantial time to materially participate. And we intend to demonstrate that the management fees paid in the tax return are clearly reasonable and not an issue where he hired someone else to run the company while he worked somewhere else. That is not the case in this. The intent of the legislature is to prevent taxpayers from taking deductions against income for investing activities. However, if the production of income is under the control of the taxpayer, and they do control the outcome, then tax law allows them to take deductions for necessary and or reasonable expenses in order to earn that income. My understanding is that the transactions in this case have more or less been substantiated. It's not an issue of substantiation of documents, receipts, and expenses, and that has all been taken care of. The issue that the state is raising is whether or not these expenses are for a valid business purpose. We intend to demonstrate that they are. Second, that the issue concerning the state is whether or not the appellant materially participated in the corporation. And third, ultimately, should the penalty be imposed for accuracy-related deductions. We will address each of those issues through Mr. Malm's testimony. And our position up front is that he clearly materially participated in this corporation in all of the years in question and the years before that and after that, that the rules that are being applied are generally designed to be applied to people who hold real estate investments for the purpose of rental. And while that's a part of what this corporation does, it's not the only thing the corporation does. So we intend to discuss those issues through testimony and address through closing. Thank you.
Thank you, Mr. Mulgrew. FTB, your opening statement whenever you're ready.
Thank you, Judge Rosas. We have a difference in understanding. This is a substantiation case. Appellant earned income of $1 million per year from his high-ranking position at a major financial institution. He was also the sole shareholder, CEO, and president of an S corporation that he formed, NBMLI Inc. This company reported expenses incurred from real estate activities, and appellant reported these flow-through losses on his personal individual income tax return that averaged $300,000 per year, and these losses offset his ordinary taxable income from his banking and finance jobs. Respondent disallowed these expenses, and we characterized these losses as passive, which cannot be used to offset appellant's ordinary income. The facts and evidence in this case will clearly show that respondent's assessment must be affirmed for three separate and independent reasons. First, we have a complete lack of substantiation for the expenses claimed in renting and renovating one of these properties. Appellant caused the company to list most of these assets as available for rent 365 days per year. Yet, despite the no fewer than 10 requests for this information since 2014 through the present, he failed to produce a rental agreement, tenant contact information, rental deposits, proof of advertising, or support the rental income.
That's just for one of the properties? You said?
That's for all the properties that were
Okay.
listed as available for rent.
Okay, thanks.
What little evidence we have shows that someone else other than appellant managed the properties. It's the law. Appellant must keep adequate records and provide competent evidence and documentation to support claim deductions. A taxpayer's self-serving testimony is insufficient, and appellant's failure to produce evidence within his control gives rise to a presumption that such evidence would be unfavorable to his case. For instance, appellant lists his Hawaiian timeshare as a corporate asset. It's listed on the depreciation schedule on the S Corporation's tax return. He reported receiving $3,000 in income for his timeshare. He also reported expenses totaling $9,000, including depreciation of $2,600 and association dues paid of $5,000 for that year. This is a timeshare. It's not available for 365 days a year, and there's no substantiation for the rental income received nor the expenses as it relates to that particular property. Second, even if appellant somehow managed to substantiate these expenses, which he has not, under California law, these flow-through losses are passive because any real estate rental activity is considered to be a passive activity regardless of the level of participation by the taxpayer. Internal Revenue Code section 1366B provides that the character of a shareholder's share of income or loss incurred by an S corporation is determined as if the income or loss were realized directly by the corporation. This is known as the conduit rule. The case on point is Valentino v. Franchise Tax Board, cited in our opening brief. Third, appellant claims that he actively managed the business of this S corporation. This is false. One thing I would like to knock out of the park right here is that Treasury Regulation 1.469-5T, B2, sub 2A, provides that taxpayers' hours spent on management do not qualify as participation if another person or entity was compensated for such management services. Appellant cannot possibly claim that he was somehow materially participating in the company's activity when he caused the company to report over $100,000 per year, every year, as paid to someone else other than appellant for management fees or outside services. And he recently came out and admitted that he paid this money to his son. He also caused the company to pay over $30,000 per year to someone other than appellant for administrative fees. It's on the record. The appellant's representative confirmed that appellant did not maintain or keep any log sheets or other records to substantiate the daily hours he spent conducting any business for the S corporation. And appellant did not provide a time log for his hours spent at his banking and finance jobs. In respondent's opening brief, we cited to numerous cases which point out that the Treasury regulations do not allow a post-event ballpark guesstimate to be accepted when a taxpayer seeks to establish the number of hours worked in claiming material participation. A recent example was the case of Bragg v. United States, 2014, where the taxpayer reported non-passive losses which flowed through to her from her real estate company which were disallowed. The taxpayer
I just want to remind you we're at the 5-minute mark. You can wrap it up, please.
Wrap it up. The taxpayer argued that she spent numerous hours and materially participated in the rental of a real estate company as opposed to her participation in her main profession as a real estate agent. This taxpayer was unable to provide calendars, receipts, reports, or any contemporaneous documentation to support the claimed number of hours spent, only estimates. And that court found that she did not meet her burden because there were no contemporaneous documents to support the narrative of hours spent. Finally, the accuracy-related penalty was mechanically applied in this case correctly because the appellant underreported taxable income by greater than 10% of the tax required to be shown on the return, or $5,000 for each tax year initially. The foregoing reasons mandate that respondent's action must be sustained. Thank you.
Thank you, Mr. Hunter. We will now proceed with witness testimony. Mr. Malm, as I mentioned during our in-person pre-hearing conference, a full copy of respondents' exhibits are in the witness box. I inadvertently forgot to add your 4 exhibits earlier. I will do that now. Just give me 1 second. Mr. Malm, whenever you're ready, you can take a seat in the witness box. Thank you, sir.
I can take my notes from.
Yes, sir.
Thanks.
And if you can remain standing while I administer an oath. You raise your right hand, please. Do you solemnly swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. You may be seated. Mr. Mulgrew, this is your examination. You may begin whenever you're
Can
ready.
we raise
Pardon?
a point of order here? If he has notes that he's going to be consulting during his testimony, I think we're entitled to see them.
Mr. Mulgrew, what notes are we discussing here in terms of Mr. Malm's notes?
He doesn't have a prepared statement. We discussed what the issues are, and he took some notes for memory purposes. There's no prepared statement. It's just his own personal notes. I personally haven't read them either.
Mr. Cortez?
Well, without looking at them, it's hard to say that it's not appropriate that we get to see them ahead of time or during the testimony.
Mr. Malm, are you intending to read from these notes?
No, it's more to keep me on track of the points that I want to try to communicate.
How about this? Put them face down. If you need to refresh your recollection or if you want to refer to your notes to help you recollect something, just indicate that in the record that you're going to refer to your notes just to help you with your memory.
Sure. I have no problem. There's 2 things. I have some written notes for myself, and then I have a kind of a fact sheet of notes. I am more than happy to share, I will use the fact sheet if I can, and I'm more than happy to share the fact sheet, and you can take a look at it.
Any chance you have additional copies of the fact sheet?
I have about 5 or 6.
Mr. Cortez, would that be fine? We'll provide you with a copy of the fact sheet.
That would be great. Thank you.
Thank you.
You have about 10.
Once again, Mr. Mulgrew, you may begin whenever you're ready. Sure.
Mr. Malm, can you describe for us what NVMLI as a corporation does?
Well, yes. NVLI is involved in kind of 3 different areas. One is real estate redevelopment, 2 in real estate projects in general. The second one is an activity around around an incubator that now student-run businesses from Bowling Green University work through that incubator. Where I actually take a position in the company and work with the company. And the third is I do consulting work in the financial services industry. So those are the kind of the key three areas that NVMLI is involved in. I think that the key behind NVMLI is that it is that me, I am NVMLI. Everything that NVMLI does, basically I do. And we'll talk a little bit later, I think, about having a project manager on a project. But as far as what NVMLI does as a company, I do. So it is my ideas, my creativity, my skills, my relationships that are leveraged to make NVMLI. You could say that I'm at the heart and soul of that. I thought that the other thing that might be helpful in thinking about NVMLI is that, to give a little history of it, there's a kind of a phase 1 and a phase 2 of NVMLI with a stint in the middle. In phase 1, after taking a .com company public, I decided to retire to Nevada. I got bored very quickly and saw an opportunity to get involved in the mortgage brokerage business. And so I opened up NVMLI in 2002 as a place that could act as the middleman between the lenders and the borrowers. And my goal then, more than anything else as well, was to create a broader business, but started through getting involved in mortgage lending. I think in the testimony, we talk about the fact that when I did leave NVMLI to take a different position full-time, that NVMLI continued to run. And part of the reason that it continued to run is I had a sister who lived in Nevada who was involved in the real estate business. And actually, one of the goals that we had was to take NVMLI and actually have a three-pronged business. Residential lending, residential sales, and remodeling activity, flipping kind of activity. So that's how kind of phase 1 started. When I was recruited by Union Bank to come in and run their investment company, which is another thing I think I should probably clear up, is that I was the president of a wholly owned subsidiary of Union Bank. I was not the president of Union Bank. I didn't even report to the president of Union Bank. Reported to a division manager in between myself and the president of the bank. But when I accepted that position, kept NVMLI running, but it died quickly because I was the heart and soul behind generating the leads that kept the business operating. And so when I was no longer there to run the marketing side of it and generate the leads, the business slowly dried up as representatives left the company. And between 2004 and 2009, I kept the structure active because I continued to look at venture capital projects and seeing if there were opportunities that I would want to invest in outside of what I was doing at Union Bank. Nothing at that point in time turned up that had any interest to me, and I had a background in that. So it wasn't like it was, I actually invested in .com companies when I was working for another corporation. And when I left that corporation, I took one of the .com companies public. So it wasn't like it was something that was out of character for me. In 2009, it was becoming clearly evident to me over things that had happened in 2007, 2008, as well as what was happening in the economy, that the opportunity for me at Union Bank was changing rapidly. And what I was hired for was no longer valid. And so I had begun to think about what would I do post my life in Union Bank. And that's when I decided that I would get involved in reactivating NVMLI and not doing lending this time, but getting hands-on involved in real estate redevelopment as well as consulting and these student businesses. So that's what MBA Online does.
So your role in the company, you basically have different aspects. You have the real estate redevelopment piece, the student incubator, and the consulting services. This is what the company does, and what do you do personally for NPMLI for each of these activities?
Based on the way it was described earlier, I know it doesn't sound like I do everything, but I'm basically involved in everything and do almost everything. As I said, I am the visionary behind the business. I'm a creative engine for the business, and so determining what I'm going to get involved in and how I might get involved falls into my lap. That side of it. Once a decision is made that I might pursue something, I'm the person who goes to the market, does the customer research, does the competitive research, and ultimately develops the strategy that we're going to be implementing. I then become the implementer, the influencer as well in the process, as well as the financier of the project. So the things that I'm getting involved with, I generally either finance it completely or take an equity position in the activity. I get involved in everything from, I should probably tell you that a little bit about my background as to what I do here and leveraging my skills. I am particularly strong at organization, strategy, picking people, and developing the business, growing the business. Those are probably my strong skills. Coming to take cost out, that's not what I do. I grow businesses and I don't kill them. So I do whatever I have to do to get the revenue. In some cases it involves doing maintenance, in some cases it involves doing advice, in some cases it involves keeping score and helping people figure out why they're not beating competition or what they need to do to make that happen. But none of it is to a point where I just deliver a report and somebody else does the work. I am very hands-on, and I thought it might be beneficial to hear a couple of examples. So in my redevelopment activity in the particular property that we're talking about here today, Estates, I was the one who identified the project, went out and looked for the property, did the research on the market and where the location would be, found the property, got involved with the architect, got involved with the city to determine what we could do, and even to the point where when the property kind of reached its final points, I did the finished grade on the lot personally. I installed the dishwasher in the house. I cleaned the windows of the house as we got to a point where we were getting the city inspectors to come out and look at the property. It's amazing what you can learn by looking at the garbage about what's going on in the project. In the financial service industry, I work with a wealth management provider in the Bay Area right now. I'm considered to be, even though I'm not an employee, I'm technically an advisor and a consultant to them. I work with them on all their business development strategy. I represent them at business meetings with their key client, Nationwide Insurance. Nationwide sees me as an extension of them and relies on what I would say to be part of the company, as the company does as well. And in the stage of developing businesses, I began a few years back to participate in a Shark Tank that was held at my university for startup companies and student-owned businesses. And so I have created a program where I invest in these businesses, I provide mentorship to the student, And that mentorship, in 2 days, I'm going to be in Los Angeles on a sales trip with the president of one of the companies as we try to expand our distribution on the West Coast. So, again, just trying to describe and give you the nature of the activity is not one. I'm on a couple boards, but the reality is that boards generally want people to have their nose in, but not their hands on. The nature of what I do tends to be more hands-on and less nose in. And so I look for projects that I can get involved on a hands-on basis.
And so one of the issues that the state raises is your lack of compensation by NVMLI seems to indicate, in their eyes, nobody would work for free. Can you talk a little bit about how compensation works when you're not an hourly or salaried employee?
Well, I work for return, okay? And so the return comes in what the venture does and its success, and I guess you could call everything the work that you're doing up until that point in time your sweat equity to get to a point where it can generate a return. It seems pretty strange to fund a business, okay, and then to draw a salary out of that business and then turn around and refund it again. So I think it just works better if you live off of your own funding, put the money into the business, and not take the money back out of the business.
So in the case of the one of number of projects going on, the States Drive, the issue here is whether or not material participation was involved, who these mysterious management fees were paid to, and what the scope of this project was. The project in the first tax year in question was acquired and dismantled. Can you tell me about what was involved in that, what you call the green teardown?
Yeah, well, we set out to do something that was different, okay, and different more than anything else at the point in time was to build something that would be greener than anything else that there was, or at least as green as it possibly could be. So that included as well the teardown of a property that had been in existence for 55 years. It was about 1,600 square feet, had a unapproved addition attached to it, was using the garage with a potbelly stove in it, and had a 6-car garage, which actually was the best building on the property, 6-car garage on the property with stones everywhere on the property, because at one point in time the owner had a collection of 26 antique Cadillacs stored on the property. So, in looking at the estate's property, it was in an ideal location, and the thought was that let's see what we can do to, obviously it would have been better for us from a certain tax side to keep a wall or two up and build around that property, but the reality was that it was better to take the whole property down. And so we had heard about this organization, Donation Solutions, and contacted them and thought that, okay, if we could recover some of our costs for demo, this would be a good way to go. And so we got involved with Donation Solutions, throw the whole property down. Everything was recycled. Every wire, every board, every piece of furniture that was left in the place, all the appliances that were there, etc., everything was recycled.
And we have photos of that. Sorry, do you have copies of the photos of that? So at the bottom of the first side of the older house, you can see where the house is being systematically dismantled so that all of these pieces were donated, ultimately reused, recycled,
Yes.
repurposed?
Yeah. In fact, they do such a great job that when you go out and see the piles of wood, it looks like you're at a lumber yard, that they're just been cleaned and they're ready to reuse.
So this was a fairly significant project, would you say?
Well, it was just the start of a significant project, because the second phase of that was actually building the property and designing the property. So, and that's what got me involved in getting my son involved in the business. And my son is a commercial real estate broker. It was a point in time where that market was a little bit soft, and so it was a good time. I've always wanted to have a business that the family could participate in, so this seemed to be like a good opportunity to be able to do that. My son never got involved in any of my other activities in NBLMI. He was strictly the person on site for this project to manage it, and what we built was a 4,000 square foot marquee property. Yeah, that's the flip side of the demo. When we sold it, my target was to try to get something in the $2 million range. I thought that the market could bear $2 million. And so that was our original goal, to try to build something within that range. When we finished the property, we actually ended up selling it for $2.8 million, and we were rated as the second greenest home in all of Contra Costa County. So we felt that we had achieved our objectives of doing that.
How many hours do you think you put into just this project alone personally?
It'll be easily 6 months of over that 3-year period of time, easily.
6 man months?
6 man months of time, yeah, easily.
And this was not management, this was what type of activities?
Whatever I needed to do. It was management as well, but it was whatever I needed to do.
Organizing.
And I mean, understanding what a subcontractor is doing and where it's going right and where it's going wrong, I know that sometimes is considered to be part of management, but it's also considered to be part of getting the job done. So,
How many houses have you built in your career?
Prior to starting this project, I had been involved in 10 new constructions, 7 of them for personal use, and 3 of them for homes that we built for either my in-laws or my own parents.
So the design, the layout, the figuring out what goes where, that was done by you on this property?
Well, I don't do the drawings.
Right.
Okay, but and it wasn't just done by me. This was done by myself, my wife, who is a wonderful stager and decorator, and has done these homes with me. The 10 that we built prior to this, done by my daughter-in-law, who has been involved in the decorating and design business since she's very young, and my son and I. So, but at the end of the day, the buck stopped with me as far as making the decisions, because it was basically, I'm the one who's financing the project, I'm the one who's got the responsibility to turn a profit out of it at the end of it.
So I want to switch a moment to one of the other issues at hand. The state raises that your earnings during these tax years is in excess of $1 million. In the Internal Revenue Service provides an audit technique guide for examiners to use to try to poke holes in cases when they're doing examinations to determine whether or not they hold water. So the state has presented an audit technique guide that says people with high W-2 earnings typically can't qualify for the material participation rules. And that's generally true, but not always true. Let's talk a little bit about your W-2 compensation during these years, and the relevance to that towards the amount of time you would have devoted to Union Bank's Highmark Capital in a one-year period.
Well, I don't think that there's a lot of connection between the two, but I'll try to answer that question. And, you know, I mean, I've made more money and worked less hours. I've made less money and worked more hours than I did at Union Bank. And in the context of Union Bank, I was hired in 2002 to come in and evaluate a business and to make a recommendation as to whether the bank exit that business or stay in that business. I looked at it as going to be somewhere between a 2- and 10-year assignment, depending on what the outcome was of the initial concept. The bank set up a compensation program for me that had 3 legs to it, and one leg was a base salary. And my salary during that period of time ranged from $275,000 when I started to $359,000 when I left 10 years later. And then what was the more important part to me was the opportunity to participate in what I would develop in the business, and if the business did develop. And so the second and third leg of the stool was I had a short-term incentive plan that was based on the revenue generation and the profitability of the business growth. That was about 65% of my compensation. And I had a second leg of that, which was in the key driver in an investment management business is the relative rankings of the performance of the investment products that you manage. And so 35% of my compensation was tied to investment performance. Based on those two criteria, there was a very formulaic-driven strategy that said I could earn up to 150% of my base salary in terms of an incentive plan. And then in addition to that, there was a longer-term incentive plan which was designed to keep me in place and put something at risk. So whatever I earned in my short-term incentive plan, I earned an equal amount in the long-term incentive plan, but it was only paid to me over 4 years if I was there during that period of time. And so it had been very formulaic right up until 2008. And in 2008, I had my best year. You know, we're talking about $1 million years here. In 2008, my total from Union Bank was over $2 million. And part of that was because part of my incentive was paid in stock. And in 2008, Union Bank decided to privatize its bank, buy their stock back, and when they did, all of my stock and stock options had to be cashed in. So my compensation was inflated that year.
And that shows up on your W-2 as ordinary income.
That's correct.
The stock, that's correct. You had no choice.
No choice. No choice in the matter. So what also got me headed in the direction of I was going to be doing something else. I introduced a very aggressive growth plan for the business. Highmark Capital Management represented about 5% of Union Bank's earnings and about 10% of their revenue. So it was not a big deal in terms of the banking business. In order to, we'd have to get up to at least 10% of the earnings in order to be considered to be something substantial or a core business. And at the peak, when I took it over, we were about 16 billion in assets. At the peak, I got it up to 21 billion of assets, and it needed to really get to 40 to 50 billion in assets to be a meaningful property inside of the bank. The only way to do that was to acquire. And so we had an aggressive growth plan. We were going to, Union Bank is a 3-state bank. The investment management business is a national, international business. If you have good investment capability, the client in New York needs it just as badly as the client in Los Angeles. So I built national distribution in both the retail and the institutional marketplace. I expanded the staff from 3 people, my direct reports from 3 people to 10 people, and we set out to build this business in the bank. In 2005 and 6, I made a couple small acquisitions, but I was never really given the opportunity to pull the trigger on anything big. And with the market correction that came with the subprime crisis, it was obvious that that wasn't going to happen. So my role of building a business and growing the business was changed substantially, and I was moved from the capacity of doing that to the capacity of caretaking the business and making sure that we avoided all the risk. And that happened in about 2008, 2009. It became very clear to me when my incentive compensation in 2009 was, the formula produced one number, and the amount that I was paid was an amount that was reduced by a percentage as an arbitrary number taken by a bank executive. So the combination of not buying anything and the combination of not really participating in the business before, but being paid like all other bankers, you might say, it is what said to me, my life at Union Bank won't be forever, and I need to think about what I want to do next. So the compensation was a critical issue to figuring out that I was going to have time on my hands, I was going to have creative energy and capacity that I could do something with, and even while I was still working at Union Bank.
So to boil that down, effectively the time periods in question today, the 2009, 10, 11, 12 period, is it fair to say that your compensation was basically severance and contract and not really related to 8-hour day, 5 days a week arrangement?
It was in 2011, February of 2011, my final boss that was on board with the strategy departed. And so it was clear from that point on that we weren't going forward with this. In 2011, I reached the conclusion, I reached an agreement with the bank that my job had materially changed, and that I was no longer the CEO of the company or the president of the company running an independent strategy, but I was now a staff vice president, you might say. And so we agreed that my position would be eliminated, and the person who came in would assume those responsibilities, who took over as the group executive. They were going to downsize the business to about 1/3 of what it was. And so from no later than mid-year 2011, I was on a kind of advisory status and not operating the company. And I formally severed in 2012 and retired at the same time from Union Bank.
So, Mr. Mulker, I just wanted to remind you, we estimated about 30 minutes for Mr. Malm to write testimony. We are at that mark now.
Okay.
You will have a chance to continue with examining Mr. Malm after FTB is done with theirs, but if you want to wrap it up soon for this portion of the examination, that would be great.
Yeah, absolutely. So in the periods in question, you're doing your exit strategy, you're resigning from your position, you're receiving compensation, but it's for performance in earlier years that's being paid out, and it's in the form of stock. You're not actually going to work on a regular basis.
In 2012, that was the case. In 2011, I was there in an advisory, not an operating capacity.
Right. Okay. So
In 2010, I was still operating, but without any commitment to strategy.
Right, but basically, you weren't committed to a full-time job.
No.
That would have absorbed all of your time away from NVNLI.
No.
Right. And finally, the management fees and the $30,000 paid in administrative fees, this is the money you refer to as paying your son for the on-site project manager?
That's correct.
And then the $30,000 administrative fee is?
Well, I actually had my daughter on my staff as well, and she happens to be very good at administrative things and creative things, so she was doing a lot of design work that we had as far as getting our message out.
How many employees does NBAI have?
That's it. Just you. Well, just me, and then during that period of time, my son and my daughter. My daughter still is engaged with NB Online and the other things that I do.
Okay. Thank you.
Thank you, Mr. Mulgrew. FTB, you may begin with your examination whenever you're ready.
Thank you, Mr. Malm. Mr. Malm, I only have a couple of questions. And I've been looking at the tax returns that we have filed by the S Corporation, and looking at the properties as individual properties. Respondents sent numerous requests for tenant information. I mean, the reporting position was that these properties were held out for rental 365 days a year. And we didn't receive any renter information back, deposits, or any supporting documents to substantiate the expenses reported on the returns for these properties. One property in particular, 1761 Carmel Drive in Walnut Creek. Are you familiar with that property?
I am.
Who lives there?
My daughter.
You reported receiving rental income for 2010, 2011, and 2012 from this tenant. Is that correct?
Yes.
Did you provide documentation of this reported rental income when requested by the FTB 3 times?
I would turn to my tax advisor. No, I don't think so.
Okay.
Other than, I mean, who reported it as income. So
That's the reporting position. My question relates to substantiation of the reporting position, the check.
no.
You previously testified that from 2010 to 2011, your job working for a subsidiary union bank morphed more from an operational position to an advisory role. Is that correct?
That is correct.
But that's still kind of vague in terms of the number of hours that were spent working at this subsidiary union bank. Could you give us the number of hours that was spent working for this subsidiary union bank for those 2 years?
Typically, I would report into work at normal time, 8, 9 o'clock in the morning. Typically, I would leave at 5 o'clock, 5, 6 o'clock. So I was working a full 40-hour week, you could say.
For 2010, 2011?
Yes, what I would say is that I was there for 40 hours a week. And there's a difference between working there for 40 hours a week and being there for 40 hours a week.
What is that difference, sir?
I could do other things while I'm there. I was just there. And I needed to be there from the standpoint that if something came up, that I could be involved in. If something didn't come up, I could be involved in other activities as well. But that, I'm not going to try to argue that with you because in my life here, there's 168 hours in a week. 40 to 50 of them could be spent at a job. There's still these 100 to do other things. Even if I take a third out for sleeping, there's still another 50 that I have something to do. So the fact that I'm there was, in my mind, kind of immaterial on that. So.
Almost the same question for tax year 2012. What's your estimate of the hours spent working for that subsidiary union bank in 2012?
2012 was a little bit different in that there were still some things that I was involved in, but well, not really, because once I entered into a severance period and stepped out of the bank, and that started in mid-year of 2012 until mid-year of 2013. Then they couldn't call me anymore to do anything. But prior to that, I would estimate that I was spending maybe 10 to 15 hours a week on Union Bank activities.
Thank you. Another asset that is listed on the depreciation schedule for the company, for the S Corporation, is a work loss space in Oakland, California. It's listed as an asset of the company. What takes place in that warehouse?
Yeah, it is a warehouse. So I have things stored there that are related to things that I do in terms of my real estate business. I have an office there, and so I work out of there. I have my files there, and keep all my files there. I have tools there, so my table saw, I have a lift, a construction lift that's there. All my hand tools that are there that I would use. There's a couple of blow dryers, you know, the kinds of things that blow to dry things out that are there. And that's predominantly it. There's no, and I know there's some contention that I guess you found a record or had found a record that indicates that the property is like a live workspace. It is exclusively light commercial and office or warehousing. And having served on the board there for 2 years as well, you know, I know that we have fined as well as have bylaws excluding any kind of residential. And I was even reminded more about that recently when I tried to acquire what do you call it, internet service there, and was told that this is only the price of commercial is so much higher than residential. I tried to get it as a residential price and I couldn't, so.
Okay. Well, that ends our cross-examination, Judge Wilson.
Thank you, Mr. Hunter. Mr. Mulgrew, by any chance do you have any additional questions for Mr. Malm?
Not at this time, thank you.
At this point, I will turn it over to the panel to see if they have any questions. Mrs. Hosey?
Hi. I had a question about the hours that your wife helped with the property. You said she staged and decorated the properties when you were selling them. Do you know how many hours approximately she attributed?
No.
Approximation?
Yeah, I mean, I'm going to say 2 or 3 man weeks of time involved in doing that work, acquiring things, bringing it to the house, setting it up. So.
Okay, thank you. No.
Mr. Margolis, do you have any questions?
Yes. Your son is his name, is he Earle Malm the second, or are you Earle Malm the second?
I'm the second.
Okay.
Yes. My son is the third, but he only goes by Drew Malm. So.
Okay, fine. I've seen there's been some arguments about whether or not you own some of these properties and LVI own some of these properties. What sort of documentation did you have transferring these properties to NVMLI?
Well, we did not, some of them were transferred into NVMLI by going through the deed process, and others were not. But they were adopted by NVMLI as a result of corporate action.
So just the corporate adoption, consent or whatever, that's the only documentation for that? Okay. And I have a question, there's something about the Form 4797 loss. Does that relate to this estate's property when you did your tear down? Is that the loss that was claimed?
Yes, that's the dismantling, the disposal of the original structure is being taken out and disposed of, and then they build new.
Okay. And let me see if there's anything else. You gave some estimates of hours that you worked on various projects, that you worked with respect to NVMLI business, but you said that NVMLI had 3 different businesses. And I'm trying to figure out how can we tell whether or not your hours related to, did your hours relate to just the real estate business or relate to all of those businesses?
No, for purposes of this, it was basically related to the real estate redevelopment business. So the hours that have been put in this document are related to real estate redevelopment.
Okay, and the Danville property, the estate's property that you sold for $2.8 million, when was that sold?
2015.
And who was living in the property before 2015?
I had my son rent it. And there was a specific reason for that.
He was the tenant?
He was the tenant, yes. And we put it into service in 2012, having completed construction. And the market wasn't right yet to sell it. So we decided, okay, you're paying rent here, go pay rent there. And let's minimize some of the bleeding during that period of time. And unfortunately, we came up with a very significant construction defect that it was a small thing, but it caused a major problem. One of the test caps that went onto the plumbing beneath the house, when the testing was done to test the service, the cap wasn't put back on and closed. As a result of that, for a period of a couple months, sewage was building under the house, and fortunate for us, we put a rat slab under the house, and as a result of doing that, it was kind of building a swimming pool. So we had things growing there, and we had to go through a mold process. We had to go through...
I had that problem in my house.
quite a new construction lawsuit. So until we could deliver it with a clean bill of health, okay, we kept it rented until that point in time and kept working on it.
So when was the property, when was it finished construction so that he moved in or whatever? So
2012.
And the Nevada property, the 385, I forget the name of the street.
Via Salvador.
So that's a residential property as well?
Yes.
And who was that rented to?
Well, that turned out to be a problem, and that is when I had NVMLI, it was a Nevada company, and I was living in Nevada, and that was my residence. When I came back to accept the position with Union Bank of California, you know, that was a very difficult time to sell a property in the marketplace. Thought I could rent that property, and I did rent it for some period of time, but there were two big issues. Did not realize that it's not a short-term rental market, so the CC&Rs precluded me from renting it like weekends, and it was a great property for that, but couldn't do it. And then the second thing is I was actively trying to market it, and it was difficult to have a renter in there and at the same time be marketing it. So it was available for Rent 365, but realistically that was probably not the right thing.
Can you repeat the name of the street?
Via Sonador, Viasonador.
And when you were talking about the management fees that were paid with respect, that was to your son?
Yes.
That was $100-some thousand a year?
Yes.
And that's for his work on the estate's property?
That's correct. And yes.
And when that property was sold, was that reported on the sub-S return?
Yes.
We'll look to him. Yes.
Let me see the anything else. And the hour estimates that you gave for the work on your real estate properties, how much of those hours was by you and how much was by your wife?
The estimate that I gave in the documents that were submitted was all by me.
think that's all for now.
May I ask a clarifying question or two, Your Honor? Judge?
Yes, Mr. Cortez.
Judge Margolis asked you if the hours on the chart that we talked about today relate, and you, I think you answered that they related to your real estate development activity.
Predominantly, yeah.
What do you mean by your real estate development activity?
The work that I was doing around estates and developing that particular project and getting that ready to go to the market.
Estates, E-S-T-A-T-E-S?
Yes.
Is
Yeah,
that the,
okay. 106 Estates, that's the property.
the
Yeah,
house, the greenhouse?
it's correct.
So those hours all relate to that project and not to the rental real estate activity? Primarily?
Primarily, yeah.
That's
Yeah.
all I have.
I didn't, there were hours related to the rental real estate activity, but I really didn't consider those.
You know, we've covered some of these properties. I think I forgot to ask about the Walnut Creek property. Who was renting that during 2010, 11, 12?
My daughter, okay, and we bought the Walnut Creek property when we thought it was a good time in the marketplace to make that acquisition. I had the cash from, you know, a little bit of windfall that had occurred from the sale of the Union Bank stock. And that property is kind of it's going to have an opportunity. We had to put some money into it and do some redevelopment to it. But we paid $371,000 for that property, and the current market value is $650,000. So at some point in time, we will flip that property.
And the Union Street and Oakland property, that's the warehouse?
That's the warehouse.
You were renting that?
No,
You own that?
that I own that, and I use that to store things that we use in the various projects and store my files as well.
And I think there's 3 timeshares in Hawaii, is that right?
Actually,
There's one in Lahaina and 2 in...
I think during that period there were. Okay, I have further developed Hawaii. I see there's an opportunity, I believe, in the timeshare space. I know everybody gets these phone calls, and you have a timeshare that you want to get rid of. But in Hawaii in particular, I thought that there could be some rental activity with that. I'm less convinced of that today than I was back at that time. So what I've been doing actively over the last couple of years is trading the portfolio and reshaping the portfolio. So today I own 11 weeks of timeshare, all on Maui. 9 of them are on one property, and 2 of them are on another property. 8 of my 11 weeks are the Christmas and New Year's week, so it's a very specialized opportunity. 6 of my weeks are all what I call premier deluxe oceanfront. So one building, I own the top floor, both corners. So you might say the penthouse floor for the Christmas and New Year's weeks. And so I think that the other change that's taking place in that market is Mexico was a good example. You got a lease on the land. You didn't actually have deeded property. In Hawaii, you still have deeded property. So NBNLI has deeds in Hawaii and owns the property. Everything now is turning to points. People buy points as opposed to buying actual property in the deeds. So I think that I'm in a position where that property can increase in value.
And during the years, the 3 properties that you owned during the years at issue, 2010 to 2012, was it primarily rented to family members, those buying properties?
It's a good question, and time-wise, I think it's about 25% was rented to the outside, okay, and then about 25% of it didn't get used, and about 25% of it was used by myself in going over there and one, using Hawaii, but also working the market and getting to know more about the market. And then 25% could have possibly gone to friends and family.
Again, that's all for now.
Thank you, Mr. Margolis. Mr. Malm, I just have a few clarifying questions. And I don't know if FTV has any more questions, but we'll get to you after the panel is completed with the questions. I know you don't mind standing up for more time, Mr. Cornett. Mr. Malm, you mentioned that all key decisions of the Nevada company were made by you, is that correct?
That's correct.
And how many directors were there during the tax years at issue?
Well, there's 3 directors,
And who are the 3 directors?
my son and my wife.
Your wife, Evelyn Malm, as a director, did she make any key decisions regarding the Nevada company's business activities during these tax years at issue?
Is she going to read this testimony? Certainly, I would want to draw a distinction between seeking the consultation and advice of those people who were also considered to be directors with me. I'm the only shareholder of the company. And so in kind of saying, okay, what do we think we want to do? Okay, I would seek that input, but when it came time to make the decision, the go or no go was my call.
And does that also apply to your son, Drew? Did he make any key decisions, or he just provided you with consultation?
He had a responsibility at the site to make decisions that would come up while on the site, of something that needed to be done. But as far as are we going to go with this solar company or that solar company, and are we going to put this type of tile in or that type of tile? Again, it was an advisory input.
Mr. Malm, I know you discussed the management fees and the administrative fee. I don't recall if you spoke about the fee in 2012 regarding the claim deduction for outside services. Can you explain these outside services?
Yeah,
It's the same thing.
Yeah, I
Just
believe
got
it.
Just got to put it into a different category.
Just put it's the same 2 people doing similar things, but it's just where it was categorized on the tax return.
So just to be clear, the $164,000 claim of outside services were paid to your son and daughter-in-law, I believe?
My daughter.
In terms of the property that was demolished, can you help me understand how you determined that this property resulted in a loss of $588,000 in tax year 2010?
You'll need Tim to do the accounting of that.
Sure. And we'll wait for your closing argument. You can address that there. That's not a problem.
No problem.
Mr. Malm, in terms of, let me back up 1 second. If this panel finds that there was an understatement of tax, we will then want to determine whether you establish that the penalty should be abated. So would you like to offer any testimony on the issue of whether the accuracy-related penalty should be abated?
Well, I was actually going to make a little bit of an opening statement, and I didn't. And that is certainly with the idea being that, there was never any intention to do anything wrong. And obviously, my reason for pursuing this matter to this point to date is I don't believe that I did anything wrong or was trying to deceive anybody in any way on this. So, I would hope that if that was a point, that it certainly would be looked at, that there was no intention on my part or NBMLI's part, which is me, to have disrespect for the state of California or for the franchise tax board.
Mr. Malm, I have one final question. Let me just preface it by saying that we have a stenographer transcribing your testimony, and the panel will have a chance to read that transcript later. And also, I've heard your testimony, and believe me, I'm taking good notes. So I don't want you to repeat yourself. That's what I'm saying. So my question to you is, other than what you've already told us, is there anything else you think this panel needs to know in order for us to make an informed decision?
I think the only thing that I would add is that it wasn't like I approached this real estate redevelopment market without having some background and experience at doing this kind of work. And I did already inform you that I had built 10 properties or been involved in building 10 properties that in various stages throughout my career. In addition to that, I did 2 major renovations. One to my current house, which was over $600,000 in renovations. So I think that it wasn't like that, I could sit back and just hire somebody to do the work for me. I had the experience that I could get involved and get in there and do it. And I didn't do the framing, but I certainly monitored the framing, and every Saturday I was out there with a level, checking to see what was going on, and did discover one grade beam problem before we actually closed the framing. So, I think that there was a lot of involvement, and probably more than I've told you about or more than I put down. I think that I probably tried to be conservative in that. And I think that the other thing is that I hope you'll take into consideration the idea that I was hired to do a job at Union Bank. I came in and I did that job, and what I thought was going to last me 2 to 10 years did from a time commitment standpoint of being there and getting paid there. But from a standpoint of workload, my workload dramatically changed in about 2008 when the subprime market came. The bank got very conservative in what they wanted to do and didn't want to do with their capital. I was in a position where I was really just maintaining a business as opposed to trying to build something and grow something. And I was also maintaining a business that I knew was not going to ever be a core business in Union Bank. And to that point, I would add that they actually have downsized the company by 2/3 since I've left. And so it's a shell of what it was.
Thank you, Mr. Malm.
And I appreciate you listening. Thank you.
Mr. Margolis?
You talked about construction on the estate's property. I thought I saw something in the brief saying that 2 properties during this period were under construction. Was there another?
2 what?
2 properties were under construction during this period. Or was there only 1 property? That was most of your time spent overseeing construction. That was with respect to the estate's property?
Yeah, I had a little work going on the Walnut Creek property, but nothing is anywhere near what the Estates was.
Thank you.
The Estates was a major project. It was a major build.
That concludes the questions from the panel. In light of the questioning from the panel, I'll turn it back to the parties. Mr. Earle, do you have any additional follow-up questions for the client? Yeah. Thank you. FTV?
Yes. Exhibit 4, which was introduced as an exhibit today, is from a brief filed by yourself that has hours spent for 2010, 11, and 12. All right. Do you have any documents from that time period, such as diaries or travel logs or record keeping that support any of these hours?
The only thing that I have is my calendar of trips that I made, but it wouldn't have that, you know, I live 20 minutes away from the Danville property, so I wouldn't have had anything relative to the Danville property that, you know, that I was there on this date. It's just not the nature of the way I operate as well. I mean,
So this brief was filed with the OTA in May of 2017, so I assume that you made these estimates approximately early in 2017 is the amount of time you spent.
So what I did keep is a project log of everything we were doing at the time in chronological order by vendor and sub that we were working with. And so in order to think about this brief, I went back and looked at all of my receipts in the chronological log, and based on what we were doing at what period of time, I tried to draw some conclusions to say, okay, these were the kinds of things that I was doing then to be involved in this area, and that's how I made my estimates.
That's it.
Anything further from FTB?
No, thank you.
Thank you, Ms. Malm. That concludes your testimony. You can return to the table. It is currently 2:40. We will take a short 15-minute break, and when we return, we will proceed with closing arguments. So we will return at 2:55 p.m. We are now off the record. Ms. Perry.
L-I. Oh, it's NB. That's gonna happen. Wait,
Stands for
NB.
Nevada Mortgage Lender.
We are back on the record. In a moment, we will begin with closing arguments. Mr. Mulgrew, you shall go first, and you will have up to 15 minutes to make your closing argument. Then FTB shall have up to 15 minutes to make its closing argument. Mr. Mulgrew, you will have the last word, and we will get back to you. You will have a chance to make a reply, closing argument for an additional 10 minutes if you so choose. Following closing arguments, if any member of the panel has any legal questions for the representatives, we will ask them. Mr. Mulgrew, you may begin whenever you're ready.
Do you want me to start with the 4797 question you had, or?
It's entirely up to you, sir, but if we do have, if any member of this panel has any legal questions after you're done, we'll ask them after closing arguments.
Okay. So I think it's very important for us to be careful about how we consider the facts, and that we make sure we look at the whole story. One thing I noticed today is this particular time period is a very heavy expense time period. The part that we don't see is the subsequent years where the income was realized. It certainly appears on its face that there's a lot of expenses and a lot of deductions and these types of things. If we were to follow the rest of the story out, obviously this property sold for a fairly large sum of money. Some of the other projects have been bought and sold and traded. So there is much more to this picture than the little piece that we're looking at. I think it's important to keep it in context. We've talked a lot about materially participation. Code section 469 says briefly that if a shareholder materially participates in the operations of an S corporation, the pass-through of ordinary income or loss is non-passive. The income or loss pass-through is passive if the shareholder does not materially participate. It also goes on to say that Congress gave broad powers to determine whether income or loss from an activity is active or passive. This is a decision as tax preparers we're supposed to make each year when we prepare a tax return. Our job is to discuss with the taxpayer what their activities were and determine whether or not we believe there's material participation. Because the rules are wide open. This is a very difficult law to manage because there's not a lot of very good case law in determining material participation because it's 100% facts and circumstance based. Because I, for example, have a client who runs an Amazon store. His job basically is to restock the Amazon store whenever his inventory gets low. He places a PO. He spends maybe 2 hours a week running his entire company and does $2 million in sales. So is that material participation? It has to be, because he's the only one there doing it, right? Does he meet a certain 500 hour, 1,000 hour, or any of those? No, but he's doing 100% of what it takes to run the company, and that's why we have that provision in there. We talked a lot about time and time cards and these types of things. I'll be the first to admit in my own company, I don't keep a time card of what I do every single day of my life. Most people don't. It's not really a reasonable standard of proof or evidence, particularly if you're involved in a large number of projects. And so, again, we're left with facts and circumstances. And we are given broad powers to determine whether or not the circumstances apply. We heard Mr. Malm's testimony, and he very conservatively spoke about the amount of time. But, you know, if you've ever bought a house, you know what it takes just to buy a house. That the process is a very long period of time. It consumes an enormous amount of your time. So the rule goes on to say a shareholder materially participates if the shareholder or shareholder's spouse is involved in the corporation's trade or business on a regular, continuous, and substantial basis. And then they provided temporary rates that gives us the material participation tests. In Respondents Exhibit V, we had submitted those tests and how we are addressing whether or not he met the material participation rules. That's been submitted as evidence. And it's important to understand the rules for material participation are really intended to apply to real estate holdings. The idea is that if you own a bunch of rental properties and you hire management companies to run them for you, and they're hiring all the people to manage the repairs and maintenance, and they're collecting rents, and basically all you're doing is cashing checks, that's where that rule is intended to apply. If you're actively involved in doing it yourself, there's now quite a bit of case law that travels down the road of real estate professional and all of those things that have been a mysterious question for a lot of years. But at the end of the day, the question is, how much time are you actually spending? But it's important to understand that NVMLI is not simply a corporation that holds rental properties for the purpose of collecting rent. NVMLI, amongst other things, as you've heard, does quite a bit of property redevelopment. You can see by the photos, he's basically taken a sow's ear and made a gorgeous silk purse out of it. I was amazed when I saw these photos. That involved the process of completely tearing down to dirt what was there in the first place and rebuilding, redesigning, a huge economic improvement for the whole neighborhood. So they do buy real estate and they do rent it out while it's being redeveloped, while it's being improved, while the market is allowing for an opportunity for selling it at a higher price. That's a part of what the corporation does to generate revenues for more projects. It also is very actively involved, as we heard, in assisting students with incubator businesses. That's a phenomenal thing in and of itself. What a great opportunity, but you know, it requires time and money, and so the corporation is generating. So when we look at the case, if you read the definition of a sole shareholder in a corporation can't possibly be passive, because a sole shareholder is the person who has to do all the work. Even if it's just an hour a week, they're the only person doing it. If the shareholder performs the predominance of duties in a corporation, the activities are non-passive. If we decide that this really was a rental property, there's a regulation that in the Internal Revenue Code that says if more than 50% of the gross revenue comes from rents in a corporation, it's automatically non-passive. So we keep hitting the same non-passive, 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 because the treatment isn't somebody who's cashing checks. The treatment is somebody who is buying, selling, redeveloping. I'm not trying to portray NBMLI as a rental property company. It's simply not. Although it does have rental activities. And this is why when I look at it and I look to determine whether or not there's material participation, it becomes very obvious to me that it could not be anything but. If it boils down to a period of time and whether or not he meets the material participation, let's take a look at the 3 years. In 2010 was the big year of acquiring the Danville property, dismantling it, segregating it out, donating all the parts and pieces, and starting to develop plans and getting permits and all of that. That alone is more than 1,000 hours. If you've ever bought a house on your own, you know that you spend hundreds and hundreds of hours just in the paperwork alone. In the 2011 tax year, what were the big events? The Oakland warehouse property was purchased. The Walnut Creek property was purchased. There was Hawaii properties purchased, and there were Hawaii properties sold. So again, more than enough activity there. And 2012, the big Danville project was placed into service. So that's closing out all the permits, getting the final pieces done, and on and on and on and on and on. So it's pretty clear that whether you had time cards or not, a reasonable person could just look at that and say, yeah, that's more than 1,000 hours worth of work in and of itself. Not to mention all of the rest of the work that was done. Any one of these activities within a tax year would have required more than enough time to meet it. The state brings up the question of whether or not these expenses are for a valid business purpose. Yet the state is the one who required us to file a franchise tax return for the corporation, which would be a valid corporation. So if they thought we should file a corporation tax return, they must concede that there must be a valid business purpose going on. That's just a logical conclusion, if you will. The interesting thing about this case is prior to us setting up this hearing, we received a letter from the state saying that they were no longer pursuing this matter, that they had decided to drop it. And that's just odd that now we find ourselves here after a very long, you know, we're talking about 2010. That was 9 years ago. This has been a protracted case for a long time that doesn't ever really seem to be about anything we can identify. So what we're trying to do is to figure out what it is. The state has brought up substantiation. If there are issues of substantiation, we have no outstanding requests for information. We've provided everything that they've asked for. If there were any sorts of confusion, this is at the examination process. At the examination process, they make their determination. So if they still have outstanding issues, I don't think the appeals arena is the right place to be asking for proof of rent.
Ms. Mooger, just want to remind you, you have approximately 3 minutes to wrap up your closing argument.
Sure.
But we will get back to you afterwards.
Right.
You will have a chance to answer questions.
The last piece is just how the 4797 was calculated. When the original property was purchased, what we did was we looked at the tax assessor's bill to determine the ratio of improvements to land. That helped us determine of the purchase price, what was the cost of the house. And then there was also the cost of the demolition and tear down and all of that built into that capitalized cost. So the property was acquired, the land and building were segregated, and then the building was demolished and disposed of. That's how that calculation was made. Submitted.
Thank you, Mr. Mooger. To be when you're ready.
Thank you, Judge Wilson. I'd like to begin my closing argument by addressing a couple of questions that were raised by the judges earlier, if I may. Judge Margolis, you asked a question about this S corporation. What did it do? More importantly, what did it do when the tax was issued with the assessment that is before this body? And I believe that's important because when you're looking at any kind of look-back test, 500 hours in the prior 3 years, what the amount of time the taxpayer spent working on an activity, it's not the entity that we're concerned about, it's the activity. The NPAs that were admitted into the evidence this afternoon, as exhibits 1, 2, and 3, these NPAs are based on losses that have been recharacterized as passive. That's why we're here. These losses do not stem from mortgage lending activity, financial services activity, student business incubators, anything else. We're focused on the properties that were listed on the depreciation schedule of this company that incurred losses and flow through to the taxpayer, and we're reported as non-passive. Secondly, a question was raised in terms of the amount of time. It is contended that the taxpayer or appellant's spouse spent on one of the properties. I'd like to note that at least one spouse must individually satisfy the 750-hour requirement. Spousal attribution may not be used for the purpose of satisfying the 750-hour annual service requirement under the regs, and the case on point is Oderio, O-D-E-R-I-O, the commissioner. O-D-E-R-I-O, the commissioner, to the 2004 tax court bill. So now to go ahead and unpack this, we still believe this is a substantiation case because this taxpayer was audited for losses which he reported as flow-through losses and characterized them as non-passive. But in order to have these losses flow through to the individual taxpayer, who is the 100% shareholder owner of this company, you have to have losses in the first place. They must be substantiated. And in this case, we're not speaking about a negligible amount. For tax year 2010, it's $301,000, of which $120 were reported as rental losses, but the taxpayer on the individual return reported them as non-passive. Rental activity on the S-corp return, yet non-passive on the individual return. Losses amounting to $291,000 in 2011 and $324,000 in tax year 2012. So these are not minor adjustments. This offset about 30% of taxpayers' income as reported for the years. So again, it's the law. The appellant must keep adequate records and provide competent evidence in contemporaneous documentation to support claim deductions or the tax reporting position. We have a narrative which is presented in a reply brief going back a couple years, not during the tax year's issue, so it's not contemporaneous. Now we have taxpayer's testimony claiming that he spent time managing one of the properties, because throughout the testimony this afternoon, we've made some headway. The panel took time and focused on property by property, and what we have are properties that were held out for rent. And under California law, that's a passive activity. There's no coming back from that. Then we have one property which taxpayer alleges one property was developed. It was purchased in 2009. It was in the process of being developed during the tax year's issue, and eventually sold 3 years after the last tax year issue here. The taxpayer also testified this afternoon that his son was the only manager strictly on site for this property, his words. So we have one remaining property that can be seen as a real estate development project, but he paid his son. So we don't have any contemporaneous evidence. We do have this narrative. Testimony this afternoon elicited that the taxpayer prepared this narrative based on work logs that we requested several times over and never seen. They were never presented to respondent. It's important to note that respondent also requested documentation supporting taxpayers' investment in properties held by this S Corp during the same time period when taxpayer was assessed for flow-through losses on his individual return. The first question the audit division asked was, do you have money at risk? Do you have skin in the game? And the taxpayer was able to show that. Well, do you have sufficient basis in these assets held by the S Corp? The taxpayer was able to show that. The taxpayer was more than able to provide substantiation on those points. But when it comes to documenting expenses from the S Corp activity or even rental income, we still don't have it. In terms of an outstanding request from respondent for support for the expenses for the assets held by this S Corporation, there were at least 6 information document requests that were sent out. I have them listed in respondent's reply brief by date, and the copies of those requests are attached to that particular pleading as exhibits. The S Corp audit was not able to generate any revenue, let's say, by looking at the reporting at the S Corp level, because you're looking at an $800 franchise fee that would be paid by the S Corporation. The S Corporation return, like a partnership return, the S Corp doesn't pay tax. The S Corp reports items of income and loss, which flow through to the individual taxpayer. That's who pays the money. So that was a call that was made on behalf of the state for efficiency purposes. Bottom line, we still don't have our answer in terms of substantiation for its expenses, which taxpayer reporting flow through to him on his return. And it shouldn't be that hard. When the taxpayer is the sole owner of a company that claims to take several real estate assets into service, upon audit, the taxpayer should readily be able to show the taxing agency who rented the property, the rental deposits, expenses, support therefore, that the expenses were necessary and reasonable in amount. And we simply don't have that here. The facts and evidence show that Appellant's S Corporation didn't conduct a trade or business activity relating to his personal assets. And by that, I'm focusing on the timeshare assets. The 3 Hawaii timeshare assets, 2 are listed on the depreciation schedule, but were never rented out. The 3rd was rented out. We don't have any support for rental income or the expenses, which are triple the amount of rent that was reported as being received. The expenses reported for one property, and this is important to note, they're listed as under construction. I heard a reference to 2 properties being developed, but there's only one during the time period of issue, and that's 106 Estates Drive in Danville. These expenses went to develop the property. They're capital improvements. They should be capitalized, or should have been capitalized, which I believe they were, when the property was sold in 2015. Second, when a taxpayer claims that he actively managed the business of his solely owned S Corporation on a day-to-day basis, upon audit, the taxpayer should readily be able to show by contemporaneous and credible evidence that the taxpayer materially participated in the activity on a basis which is regular, continuous, and substantial. The taxpayer was compensated for services. There's an argument here that there was a payout in the end, and that's the sale of a capital asset. And the third-party management company was not paid for day-to-day oversight and care of operations. And we don't have that here. The facts and evidence show that Appellant did not materially participate in S Corporation's activity when he never got paid. The company paid someone else to manage it. He can't show he visited the properties. When asked, appellant did not provide any documents to show the hours he worked during the tax year issued for either the S Corp or his banking and finance jobs. The testimony listed this afternoon shows that he spent 40 hours a week at his banking and finance jobs, his primary pursuits during the first year and half of the second year issued before this panel. Appellant and his representative have confirmed that he did not maintain or keep any log sheets or other records to substantiate the daily hours he spent conducting business for the S Corporation. And again, that's important. And look at the taxpayer. He managed a company, a financial company, a subsidiary of a major bank with $16 billion under investment management, earned $1 million per year, but claims he spent hours every week in an open loft waiting on materials that were being delivered for a job site located 20 minutes away in the Bay. This taxpayer knows the importance of keeping records. It's the law. It's every taxpayer's obligation to do so. This taxpayer knows the importance of keeping binding contracts in case something comes up. And here we are. It's under scrutiny by the taxing agency, and we don't have a piece of paper to support the hours claimed to be spent pursuing this S Corporation activity. Thus, the appellant simply has not met his burden to show that these flow-through losses, which are unsubstantiated, are non-passive. Finally, on the last point, the appellant has not pled nor proven a defense to the accuracy-related penalty, again, which was applied mechanically. Revenue and Taxation Code Section 17551 clearly provides that losses passed through to S Corporation shareholders are limited by the passive activity loss limitation under Internal Revenue Code Section 469 and California law, which mandates that all rental real estate activities are passive. Therefore, there's no reasonable basis to take this reporting position on the returns filed for 2010, 2011, and 2012. Respondent's action must be sustained. Thank you.
Thank you, Mr. Hunter. Mr. Mulgrew, whenever you're ready, you have additional time to make your reply argument.
Thank you. First, I would point out the K1 pass-through is made up of two elements, an ordinary income and a rental real estate income. The ordinary business losses for operating the corporation are reported in the ordinary box, and the ones that are specific to rental properties is in box 2. This is typical way to structure. The Internal Revenue Service says rent is rent. So if you have a property that's out there available for rent, it goes on the 8825. How you treat that, ultimately in the end, is treated as a bundled K1 to the shareholder, because you rarely have a situation where you have an S Corp or any pass-through entity that has passive as well as non-passive activities. It either is or it isn't. Our contention is that it is, because it meets the burden. The state referred to the spouse's hours not being able to be included in the 750-hour test. Mr. Malm testified that the hours provided did not include the spouse hours. Those actually are above and beyond. The state talks about substantiation. Again, we're back to, if this is a substantiation issue, this is an examination. We're at the appeals process because the state has made a determination. In my pre-hearing brief, I talked a little bit about how this case transpired. The problem is the very first day that this case came out, the state was looking for unreimbursed employee expenses and wanted us to substantiate them. They didn't exist, because we didn't claim them on the taxpayer's tax return. So what are we supposed to provide? The state conceded that they made a mistake in how they looked at the tax return. But because the examination was open, they decided to continue on. The next layer was the pass-through losses. They wanted to see the tax returns from NV and MLI. Our first question was, do you have jurisdiction to go through a corporation that is from a different state? Demonstrate to us that you have that jurisdiction, which they were unable to do, and ultimately we voluntarily did provide them with the NVMLI Corporation tax returns, but that's the whole mystery behind why there was this seemingly uncooperative nature. We have the right to ask, our job is to defend our client and his rights, and so the question is, do they have jurisdiction? They were not able to show it. They talk a lot about work logs. I discussed that. They talk about rental income. So, anecdotally, this morning, as I was leaving my house, my tenant showed up and paid me the rent for my property. United States currency. Does this actually make it to the bank? Can I show a copy of this? If somebody were to come and examine me to determine whether or not I collected rent, the thing of it is, no matter what I decide to do with this money, as long as I claim it as income, I have complied with the law. So, they've never seen evidence that rent was paid, yet rent was declared. There's a lot of ways rent could be paid. You could impute income. For example, Mr. Malm had a family member stay at one of his properties, and we imputed rent income. He didn't charge them, but it's not proper to have a corporation own a piece of property and not receive the benefit of it. So we imputed income to him. There's no receipt for that because it's an imputation on the fair market value of something. So we keep coming back to this substantiation issue over and over. How do you substantiate time? How do you substantiate something that did or didn't happen? Most people don't keep daily logs, and even when they do, most examiners don't accept them. We have cases where people are using apps to track their mileage, and the Internal Revenue Service has denied it because they don't see it as contemporaneous. But it's the modern age. This is how things are done. People don't have logbooks in their car with different colored pens anymore. Those days are long gone, right? The average person has so many irons in the fire, they don't keep track of everything that they do. It's not reasonable. What is reasonable is to look at what MVMLI did each of these tax years and determine whether or not that could reasonably be done in the period of time required by the law. And we submit that a reasonable person could look at these activities and say, yeah, very clearly, it would take at least that much time. So you are allowed to arrive at reasonable to conclude. And we submit that any reasonable person would conclude that the time is there whether or not there's a time clock or a time card, which is not how things are done in the real world. Money at risk, yes. Basis, yes. He talked about capitalized costs. Well, with estates, the only deductions that were made prior to the sale were for property taxes and insurance. And yes, you can elect to capitalize those costs as part of your cost of construction, or you can absorb them as operating costs. Since it's an operating project, we elected to take those costs as operating expenses related directly to the property. We did capitalize 100% of the cost of construction, and when the property was sold, that was the basis that we used. And any depreciation that we did take along the way was recaptured properly at the time of sale. So, if we have issues of substantiation, I don't have any open IDRs. If you want to substantiate income, that's an unusual request, but okay. The question at the end of the day is whether or not it's reasonable to conclude that he meets the burden of non-passive in nature, and if you read through the 7 tests, based on the testimony that you have, you could very easily, reasonably conclude that it would take that much time. And since he's the sole shareholder, he's the guy at the end of the road. And the project manager was specifically to that site, but that doesn't mean he didn't have involvement in that project as a whole. He's the guy 100% at risk. His son doesn't have any money at risk. He has 100%. And we're not talking about a little kid. We're talking about a 40-year-old man, right? His son is not just some young kid. These are adults who run their own companies. And what's unusual about hiring family? That seems to be a stumbling point, but I would much rather hire some of my family. Cautiously, right? But if you're going to share the wealth, as it were. And it's perfectly reasonable that because of the issues that they ran into, for example, with the estate's drive, that, hey, if your son is paying rent someplace else, why not pay rent here? You can manage the crisis problems, and at least we're not losing money. Is that wrong? I don't think so. Is it proper to say that's income? Absolutely. Did we say it was income? We absolutely did. I believe I've addressed the points. Thank you.
Thank you, Mr. Mulgrew. I will now turn it over to the panel to see if they have any legal questions for either representative. Mrs. Hosey?
Yes, I do. For Franchise Tax Board. Mr. Hunter, you stated this was a lack of substantiation case. I was wondering, why did FTB recharacterize the loss instead of disallowing it altogether if there was a lack of substantiation?
Well, on the individual tax return level, the losses initially were recharacterized as passive and non-passive. And then, during the same exam, same process, we asked questions, what does NPMLI respondent requested information about what this S corporation did, what services did it perform? Because respondents only have the loss amounts, and in the opening brief, it was even written that this S corporation didn't receive a penny worth of rental income, and that was wrong, because we had limited information that was from the federal government. We respondent requested the S corporation returns. It wasn't a matter of establishing jurisdiction over a Nevada corporation. Whether the Nevada corporation is reporting items of income or loss based on 3 properties located in this state, they have a filing, this California source income or loss, there's a filing obligation that's affirmative. Once that was understood, the S corporation's returns were received, and then the audit focused on substantiation. So the only information in terms of the amounts of these losses were passed through to the taxpayer on the resident individual tax return, and the numbers taken from a Form K1. So it took time to get to the procedural posture where this agency could then request substantiation for expenses reported on returns, because the agency was then in possession of said returns.
Thank you. No, okay, thank you.
Thank you, Mrs. Hosey. Mr. Margolis?
I guess I'm going to follow up on Judge Hosey's question. So, I want to address why your substantiation argument of whether they are new matters on which the FTB bears the burden of proof, because the notice of action, notice of proposed assessment, as far as I can tell, they both said they were disallowing this on the grounds that these are passive losses, not active losses, not that these were not losses at all. So I just want to give you let you respond to that.
Well,
was the substantiation for the loss at all in question prior to the filing of this appeal?
At the protest level, the outstanding issues were the characterization of the losses, Judge Margolis. And in a conversation with the protest hearing officer, it was raised, what about these losses, and how can this agency make the determination whether these losses are bona fide losses or not? And the response that was received was, you don't have tax returns. There's no way to appeal the loss amount. So the NOA moved forward on the characterization of these losses. They were disallowed for the years at issue. That's what gives rise to the assessment.
They were disallowed as active losses. They were allowed as passive losses, from what I can tell.
Disallowed as non-passive losses and allowed as recharacterized as passive losses going forward. However, we're here now, and my agency is duty bound to collect the correct amount of tax. And if this is a 100% shareholder of an S corporation, it's the appellant that causes a corporation to report these expenses and take that tax reporting position. And if there's not a valid business loss, then there is nothing to flow through on the individual side, on the individual return.
Okay. I did not, moving to Mr. Mulgrew, I did not follow exactly what you're saying. You're talking about the estate's property and that only the real estate taxes and something else were capitalized?
Oh, no, actually, when we were talking about the flow-through expenses on the K1, the state had brought up that all of the project costs should have been capitalized. And what I was saying was all the costs of construction, all of the insurance, the carrying costs and all that were capitalized. The only thing that was pushed through on the 8825 was I believe the property tax and the insurance costs. And that's an election to either take the expense now or carry it as cost of construction.
And then I'm somewhat unfamiliar with the loss on the 4797. Didn't you report some sort of gross receipts? You know, was it you claimed a net loss, but wasn't there some positive gross receipts report on the 4797?
No.
No, it was just purely
Just the disposal of the
value of the property. Okay.
Right.
And I think that in your briefs you talked about the composition of the losses for each of the 3 years, and I guess for 2010 there was a 4797 loss that was rather large, and then there's some ordinary subchapter S losses, and then there's the rental real estate losses. How, if we were to find out that, I mean, if we were to determine that, let's say the rental real estate activity, that those should not be allowed, how do we know that the other losses, I mean, don't they also relate to the rental real estate activity to some extent, or no?
Not necessarily. They would be things like travel costs to go to, these incubator businesses. They could be travel costs to sourcing properties. It could be a lot of different related things. Cell phone. NBMLI did buy the Oakland property, and so the property taxes and the insurance and all of that would certainly be an operating cost of the main corporation, because the Oakland property is not a rental. So that'd be like paying rent, right?
I thought he pays rent to himself on the Oakland property.
No, the corporation owns that asset. It just pays the costs of it.
Okay. But there's no income during our years reported from the incubator activity, I don't believe, is there?
Well, there wouldn't be, because only until those businesses mature and turn into either a liquidation of his holdings or a distribution of income from them.
And
so these are basically students who are advanced degree business students and who are starting a company.
Who holds the interest in these properties, Mr. Malm or NBMLI?
NBMLI would be the investor in their company. And then Mr. Malm would provide his consulting services and these types of things. And so at some stage when that business matured, it would either pay him or pay the corporation income based on the shareholdership, or those shares would be sold or lost if the company didn't perform.
And I guess I'll let each of you respond to this. I'm not really sure, but if some of these properties were acquired, is there an issue as to whether or not some of these properties were acquired for investment, or whether or not they were acquired for, for rental activities? Is that one of the issues in dispute? Because it seems to me that if you have a passive activity and it's 100% passive, regardless of whether Mr. Malm does 100% of that business, he's still passive. Now, obviously, your position is certainly with these properties required more than were not passive activities or rental real estate activities that he was actively engaged in. But I guess both sides, I'm a little confused in this area, so maybe both sides can just talk about whether or not these properties were held for investment or for rental activities. Maybe Mr. Malm.
Sure. Well, it's difficult to ever say that real estate is not held for investment purposes. I mean, obviously, we all expect to make money on our primary homes one day and or to buy properties. The idea of buying the properties is to buy a property such as the Walnut Creek property that's a diamond in the rough. This is a particular corridor in Walnut Creek that now has been developed into a huge area for properties and rentals. So you buy a diamond in the rough property. This would have been an older property. You rent it out, or you redevelop it, and then you rent it out, waiting for the market to mature, and then down the road sell it. So it's for the purpose of having, holding, owning, and renting, and then ultimately selling. But in the active years, you have rents, and rents are always reported on the 8825s.
Mr. Hunter?
In terms of that, the focus was whether these assets were placed into service or indeed title was held by the S Corporation. I believe Judge Margolis, you asked that question. So you have a taxpayer that has 3 Hawaiian timeshares during the time period of issue. They're reported as being held out for rental. There's one that's being reported as renting. The other 2 are listed and depreciated, but there's no rental income therefore. But they're depreciated and there's expenses that were reported related to those properties. So the query there was, were these active trade or business deductions, or were these assets that were personally held by the taxpayer and he took the position that they were owned by the S Corp? And the only documentation that we have to show that they were transferred to the S Corp were minutes that were entered into by the taxpayer and a couple of directors, and which were provided many years later. The case on point is Hoffman. It's cited in our opening brief. It's HLFFMN, in which a taxpayer cannot use a bail of an S corporation to incur or flow through as business expenses, which are expenses which are truly personal in nature. You can't do that. You own the timeshare. If your family goes there, it's your timeshare. They're not placed into service. So that goes to whether or not these expenses were reportable and substantiated in order to flow through to the taxpayer on this individual return. I'd also like to address something that you focused on, Judge Margolis, because this S corporation held several real estate assets. Now, take out the timeshares, which I just discussed. You unpack the open property, which is not being used for rental. You have a condominium in Walnut Creek. You have a Villa Solador residence in Nevada that are listed as being rented, substantiation in common loss items, and then you have the Danville property. And the question was asked earlier, these management fees that the company was paying over $100,000 every year, those fees don't relate to the rentals, do they? The answer is no. They relate to Danville. So you have, for instance, in 2010, you have pass-through losses in the amount of $181,000. That's made up of $144,000 in the management fee that was paid for Danville, and then $3,700,000 for the administrative fee, which it was testified to that also went to Danville. But Danville was the property that was being developed. So these are expenses that were incurred that benefited the property, this beautiful property that you have in the color photograph sitting before you today. Those expenses should be capitalized. It's not limited just to property tax and depreciation that was recaptured. This is hard money that flowed through as a loss, reported as non-passive on the taxpayer's individual return.
So David, again, I add one item to that too, please. Just like to establish the material participation regulation 1.469-5T. Small b as in boy, small, two little i's. And that talks about certain management activities. And the taxpayer here described his activities that were related to the estate's property, but he also described and were aware of the payment of $100,000 a year to his son. And in going to the test of whether the taxpayer materially participated in the activity, the regulation states that individual services performed in the management of an activity shall not be taken into account in determining whether such individual is treated as materially participating in such activity, unless no person who performs services in connection with the management activity, other than the taxpayer, receives compensation. So since the payment of compensation for the management of the project to the son occurred, the taxpayer's own participation cannot be considered as materially participating by virtue of the regulation.
No, that says that it can't, his time that was paid for can't be considered in Mr. Malm's time consideration.
No, it says that the individual services performed.
Gentlemen, we're free to disagree. Both of you have done a great job briefing this exact issue, and we look forward to reading the pleadings. But thank you very much for your time and your arguments. Mr. Margolis, do you have any additional questions?
Yes. Just to the extent that these passive losses are not allowed, I'm wondering, does that affect the gain that you report in the sale of the property, or does that affect your gain when you wind up the sub-S?
If they were to be recharacterized, we would have to amend 2015's to release all of the passive losses at that time. Because when you sell a property, any suspended passive losses get released at that time. So they would become ordinary losses in the year of sale.
Right, but your returns aggregated the losses from all of your real estate activities. So I don't know how you can determine which of these allegedly passive losses should relate to the estate's property versus the Hawaiian property or the Nevada property. I mean, if you're going to...
Well, if you were to recharacterize them as passive, you'd have to make that determination as to how much was passive from each one. Because certainly the 1120S wouldn't be passive. Those are ordinary losses of a sub-S corporation, sole share corp. The only thing in question would be how you would treat the rental property losses.
Okay, I wasn't sure if you looked at the rental activity in total, or if you looked at each individual property.
Yeah, so on the tax return itself, it's made up of different parts. You have the 1120, and then the 8825 is by property, right? And so you have different numbers by property. So if you were to, if I were to go back and recharacterize some as passive and others as not, they would then roll forward, and then when the property is sold, they would be released.
Okay, and do you agree with that, Mr. Hunter's characterization?
Yes, I agree with that. However, the properties are listed among themselves and delineated in terms of the rent received, expenses that were incurred per property, and the depreciation that was taken against the basis of each property. And then we have a number, a general number, for expenses for the corporation, which flow through to the taxpayer. And that's the management fee, the administrative fee. There's testimony this afternoon that those are related to DANCO. So you have to make a determination that these losses, the taxpayer pays tax for taxes in issue because they're not, these losses are recharacterized as passive, not non-passive, so that's tax bill. But if it's to carry them forward, they're in suspense until 2015. And then when the income producing property is disposed of, then they're opened up and you could take that against the capital gain of $1 million as reported.
Well, wait, what is there in the record to show that the management fees and the admin fees went into the ordinary side, the ordinary losses, rather than the rental real estate losses?
That was the way they were reported.
Okay.
On the individual return or on the K-1.
Okay.
And they properly belong there because they're not really specific to the property. I think Mr. Malm's testimony, he was talking about the estate's project and how his son worked directly with the estate's project. But that doesn't, never intended to be said that 100% of his compensation was only for that project.
Okay, and one final question.
And certainly the daughter as well, who isn't related to that property, she's related to the business as a whole, she still provides administrative services.
Well, this question is how much was related to Danville, because that's the amount that will be carried forward, it's the percentage.
Right, gentlemen, if we can avoid the side-by-side conversation, we'll just answer the questions posed by the panel, but thank you both very much for your...
You're being very helpful.
Yes, sure.
And finally, there was argument in your briefs that for Form 4797 losses, that the passive activity rules do not apply to them. FTB, Mr. Hunter, do you agree that to the extent that you're claiming the loss on the 4797, the passive activity rules apply, or do not apply?
Initially, that was recharacterized as passive, because we didn't have any information in terms of the source of that loss. We just had K1 in the federal tax information. But the testimony and where we are this afternoon, the taxpayer was in the real property development business in terms of that one particular property. So that is a loss. I'm not sure if the property was condemned in any event that would force this demolition, because it was demolished, and there's a number. That particular number, again, we lack substantiation on it, and we just now know the genesis of that number. So the taxpayer purchased the property for $691,000, and it's listed on the depreciation schedule, and there's depreciation deductions being taken against that cost basis. In 2010, there's not. Danville?
I don't think not appreciate it when it's being disposed of. But.
Okay, so
And even if there was, we would just aggregate out of the 4797.
if you look at the S corporation returns for 2011 and 2012, there's land and there's a basis of $680,000 going forward.
But it's not land is carried forward because the land wasn't disposed of, just the building was disposed of.
So those
Yes, my question, just to make clear, is the 4797 loss claim in 2010, originally that was disallowed because FTB claimed it was subject to material participation rules, and now you're admitting that that loss is not subject to material participation rules. Is that correct?
Judge Margolis, at this point in time, I'll concede that. Now we have the information.
Okay. That's all my questions.
Thank you, Mr. Margolis. I had a few questions for representatives, but my questions have been answered as part of the other questions from the panel. So that concludes the hearing for today in the appeal of Earle and Evelyn Malm. The record is now closed, and this matter is submitted as of today, April 30th, 2019. This panel shall issue a written decision to the parties no later than 100 days from today. Thank you all very much.
Thank you very much.